ladies and gentlemen, distinguished guests. Good evening and a warm welcome to the Bavarian representation to the European Union, or as we would say in Bavaria, Grüß Gott. My name is Madeleine Santana Philipp, and I'm responsible for Home Affairs at the representation. Allow me also to convey the greetings of our Head of Representation, Dr. Hartmut. As Bavaria's voice in Brussels, I'm very pleased to welcome you for another high-level debate on one of today's most debated topics, data protection. Our sincere thanks goes to our partners whose commitment and close cooperation have made tonight possible. The fact that this evening is taking place once again reflects the trust we have built and the value of our continued exchange. I am particularly pleased to welcome the European Data Protection Supervisor, Mr. Wojciech Wiewiorowski, the German Deputy Federal Commissioner for Data Protection and Freedom of Information, Mr. Andreas Hartl, and the Bavarian State Commissioner for Data Protection, Mr. Thomas Petri. Tonight's event brings together key voices from across the European institutions to discuss the digital Omnibus proposal as both an opportunity and a driving force for future innovation. Thank you very much for being here tonight. I wish you an inspiring and insightful evening.
Guten Abend, meine Damen und Herren. Es ist mir eine große Freude, Sie herzlich willkommen zu heißen. Mein herzlicher Dank gilt der Vertretung des Freistaats Bayern bei der Europäischen Union für ihre Gastfreundschaft. My name is Olivier Rossignol. I'm the Head of Information and Communication at the European Data Protection Supervisor. Today's event offers a vital forum for an informed and forward-looking exchange on the European Commission's Omnibus proposals, a set of targeted adjustments to the EU's digital regulatory framework, including key aspects of the GDPR and the AI Act. These proposals aim to streamline compliance, reduce administrative burdens, and uphold robust fundamental rights protections, all while fostering a more cohesive and future-proof digital landscape. Let me begin by thanking our co-organizers, the German Federal Commissioner for Data Protection and Freedom of Information, the Bavarian Data Protection Commissioner for joining forces with the EDPS to make this event possible. And of course, our sincere thanks go to our generous host, the representation of the Free State of Bavaria to the European Union. Before we begin, a few housekeeping notes. This event is being recorded, but it's not live-streamed. The recording will be available a few days after the event on the website of the EDPS. During the panel discussion, there will be an opportunity for questions from the audience, but please ask your questions at the end of the discussion. And finally, after the formal part of this debate, we invite you to stay for a reception with food and drinks. To open this evening's program, we are honored to begin with a video message from Joachim Herrmann, Bavarian State Minister of the Interior, Sport and Integration. Minister Herrmann's remarks will set the stage for discussions ahead. I invite you to watch his opening address. Please join me in giving him your full attention.
Sehr geehrter Herr Wiewiorowski, sehr geehrter Herr Hartl, sehr geehrter Herr Professor Petri, liebe Teilnehmerinnen und Teilnehmer, meine Damen und Herren, Ihnen allen auf diesem Wege ein herzliches Grüß Gott in der bayerischen Vertretung in Brüssel. Ich freue mich, dass diese hochkarätige Veranstaltung nun schon zum 3. Mal stattfindet. Als bayerischer Innenminister halte ich den fachlichen Austausch über das Datenschutzrecht für unverzichtbar. Daher vielen Dank an die Organisatoren, an den europäischen Datenschutzbeauftragten, an die Bundesbeauftragte für den Datenschutz und die Informationsfreiheit und an den bayerischen Landesbeauftragten für den Datenschutz, an ihre Mitarbeiterinnen und Mitarbeiter sowie das Team der bayerischen Vertretung. Letztes Jahr habe ich im Rahmen dieser Veranstaltung die Hoffnung auf mutige Schritte seitens der Kommission geäußert. Ich freue mich, dass die Kommission diesen Mut gefasst und die Digital-Omnibus-Verordnungen insbesondere mit Änderungen an der Datenschutzgrundverordnung vorgeschlagen hat. Eine Passagierin, die aber unbedingt noch im Omnibus mitfahren sollte, ist die Herstellerverantwortung. Wenn Hersteller und Anbieter selbst für die Datenschutzkonformität ihrer Produkte und Dienstleistungen verantwortlich wären, würde das für alle Nutzer erhebliche Erleichterungen bringen. Zumindest sollte die Pflicht zum Datenschutz durch Technikgestaltung in Artikel 25 der DSGVO auf die Auftragsverarbeiter erstreckt werden. So diskutiert es der Rat ja aktuell bereits. Fachkreise und die Gesetzgebungsorgane der EU diskutieren den Omnibus kontrovers, so wie Sie es heute vermutlich auch tun werden. Diese Diskussionen sind für die gute Gesetzgebung essentiell. Am Ende müssen echte Verbesserungen stehen. Wir müssen bestehende Rechtsunsicherheiten auflösen, wir müssen Innovation fördern und bürokratische Hemmnisse abbauen. Nur so können solche Verbesserungen erzielt werden. Meine Damen und Herren, deshalb ist der heutige Austausch über Datenschutz und Innovation besonders wichtig. Ich wünsche Ihnen viele Erkenntnisse und interessante Gespräche. Alles Gute.
We are now very delighted to welcome our keynote speaker, Talus, Chair of the European Data Protection Board, EDPB. Ms. Talus is a driving force behind Europe's data protection framework, from GDPR implementation to shaping global privacy standards. Anu, the floor is yours.
Dear Wojciech, dear Andreas, dear Thomas, ladies and gentlemen, the digital ecosystem we regulate today is multifaceted, multi-layered, and evolves at great speed. A single platform can be a marketplace, a gatekeeper, an advertiser, and an AI-driven service provider. To address this reality, the European Union has built a comprehensive digital rulebook. The Digital Market Act, the Digital Services Act, and AI Act, alongside the foundational GDPR. This regulatory framework is necessary, but it is also complex. Businesses, particularly SMEs, struggle to navigate overlapping obligations. As regulators, we must ensure that complexity does not become a barrier to compliance or innovation. Our goal is clear: to turn regulatory complexity into legal certainty. This certainty will in turn lead to trust, which serves both innovation and fundamental rights. The EDPB is committed to making the current legal framework work in practice. We do this in 3 ways. First, clarifying how laws interact, because businesses need to know what is expected from them. Second, by engaging closely with stakeholders, because regulation must reflect real-world challenges. By supporting compliance, because trust is the foundation of the digital economy. Our message is simple. Through clear guidance, we can make complexity manageable. Of course, we are not deaf to the loud calls for simplification. The Draghi report highlighted the need to reduce administrative burdens to boost Europe's competitiveness. The Commission has responded with proposals like Digital Omnibus and AI Omnibus, aiming to cut the red tape. The EDPB supports simplification, but not at any cost. We welcome efforts to reduce unnecessary burdens, particularly for the SMEs. For example, we endorse the Commission's proposal to exempt smaller companies from record-keeping obligations under GDPR, except in high-risk cases. This is a pragmatic step that eases compliance without weakening protections. We also support key elements of Digital Omnibus, such as increasing the threshold for data breach notifications and extending the time allowed for reporting, as this has proven to be suitable. Common templates for data breaches and data protection impact assessments, as this brings more harmonization. In fact, we are already rolling out these templates before the Commission put forward its plans. New derogation for biometric authentication, where verification tools remain under the individual's sole control, as in this case, the risks remain limited. And harmonizing the definition of scientific research, as this enhances legal certainty. However, we firmly oppose any change to the definition of personal data. Why? Because the Commission proposal goes beyond the jurisprudence of the CTA EU, and the definition of personal data is the cornerstone of the GDPR. For individuals, a broad definition ensures that all identifiable information is protected. Narrowing it would leave people exposed. For businesses, an unclear or fragmented definition would create legal uncertainty, making compliance harder, not easier. For global standards, the EU's approach is a benchmark. Weakening it would send the wrong signal to our international partners. The EDPB is already working to clarify these issues, including through upcoming guidelines on anonymization, which will reflect the latest Court of Justice case law. Simplification is not the magic wand that will make Europe more competitive. True competitiveness comes from stability, incentives to invest, access to investment, and skilled workforce, and last but not least, legal certainty. And herein lies exactly our task as regulators, to provide stability and legal certainty by ensuring consistent application of the GDPR. The Helsinki Statement, adopted by the EDPB little less than a year ago, in July 2025, is our commitment to clarity and efficiency under the existing framework. Since then, we have taken action to facilitate compliance. We have asked stakeholders which templates would help them most. Based on their feedback, we are developing standardized tools to legitimate interest assessment, records of processing activities, and privacy notices. These templates will be added to the template we will make available shortly, namely for data breaches, and the one that is currently under public consultation for data protection impact assessment. We have published over a dozen accessible summaries of our guidelines, making key points easier to grasp for non-experts. For example, the summary of the EDPB guidelines on legitimate interests explains in 2 pages and in 3 steps how and when to use this legal basis. We engage at an early stage with our stakeholders and ensure utmost transparency. We do so through dedicated stakeholder events to make sure our guidance addresses the real-world challenges they face. We publish reports on these events, reflecting the input we have received from stakeholders. And we also systematically organize public consultations on our guidance. To ensure harmonization, we will soon allow stakeholders to signal inconsistencies between national and EDPB guidance via our website. Defending fundamental rights means not standing still. The GDPR and the EU Digital Rulebook as a whole are not static laws. They are a living framework, evolving through interpretation, enforcement, and, where necessary, reform. 3 principles will guide us in the years ahead. Simplification must serve fundamental rights, not undermine them. Cooperation between regulators, with businesses, and with global partners is essential. And trust is a key in the digital economy. Without trust, innovation stalls, users disengage, and businesses lose their legitimacy. The EDPB and its members will continue to lead by example, by clarifying complexity through practical guidance, by enforcing fairly but firmly, and by promoting a human-centric approach to digital regulation, one that balances innovation with dignity, growth with rights, and efficiency with trust. The EDPB stands ready to continue its efforts to ensure that our regulatory framework remains fit for its purpose, future-proof, and faithful to the rights of every individual in the European Union. Thank you.
Please join me to thank once again Minister Joachim Herrmann for his insightful opening remarks and Anu Talus for a compelling keynote speech. Now it is time for our panel discussion, which will explore key questions concerning legal certainty, regulatory coherence, the preservation of the GDPR's level of protection, and how to further strengthen the protection of fundamental rights, innovation, and competitiveness within the Union. Therefore, let me introduce our panel moderator, Johannes Baumann, founding partner of Baumgartner Baumann, and a preeminent expert in data protection and IT law. He is a published author, frequent conference speaker, and co-chair of the AIPP Knowledge Net Berlin. Johannes, the floor is yours.
Thank you. Good evening, and a very warm welcome also from me. I would ask the panelists, please, already to come to the stage, and I will then briefly introduce you before we start our discussion. Yeah, I think there's no seating order in the sense, so yeah. I feel very privileged to moderate this panel here today. As a true Münchner Kindl, which translates into a person who was born and raised in Munich, I feel very happy here to be in this very humble location, the very humble home of the Bavarian Embassy. We will have 2 rounds of discussions for the panelists, and we will have 15 minutes at the end, at least, for you all to ask questions. And I will assume there will be plenty of questions given the complexity and the urgency of the topics that we discuss here. In the first round, we will more focus on the current state of play of the Omnibus itself, and in the second round, we will then look at the next steps following the Omnibus, in particular the digital fitness check. Just a few introductory words from me before we start the discussion. As all of you know, there are few policy areas evolving as rapidly as Europe's digital agenda. Across the EU, policymakers and regulators and businesses and citizens, and also us lawyers, are grappling with fundamental questions about data protection, data access, data sharing, the use of AI, and at the same time, digital innovation, competitiveness, and the trust in emerging technologies. Over the past decades, the EU has built on one of the world's most comprehensive, and as someone from a practical perspective, I can tell you one of the most complex digital regulatory frameworks, from the GDPR to the Data Act to the Data Governance Act and recently to the AI Act. The Union has sought to establish rules that protect fundamental rights while enabling innovation and economic growth. Precisely in this context, in which the Commission's simplification agenda have gained momentum. The objective remains to ensure that Europe's digital rulebook remains effective, coherent, and future-proof while preserving fundamental rights and safeguards that are at the very heart of the European project. But the main question here is, are we on the right track to achieving these goals? To discuss this question, we are fortunate to have an outstanding panel representing the key stakeholders shaping the EU's digital future. I'm delighted to welcome our panelists, starting from what is your left to right. And when I say left and right, I really only refer to the order of the chairs, arrangement of the chairs. We start with Andreas Hartl. He is Deputy Federal Commissioner for Data Protection and Freedom of Information, which is one of many, many German supervisory authorities, but one of the more visible and increasingly important ones in Germany because they also get the special competency for enforcing the Data Act in Germany. We have Victoria de Ponson, Secretary-General of the European Tech Alliance, who's bringing us the business perspective. We have on the panel Renate Nicolai. She's Deputy Director General of the Directorate General for Communication Networks, Content and Technology, easier to remember as DG Connect. We have Michael McNamara, member of the European Parliament and rapporteur on the Digital Omnibus and on AI, and Marina Kaljuran, she's also member of the European Parliament and rapporteur on the Digital Omnibus on GDPR. And we have Maki Tsoku, she's chair of the Council of the EU Working Party on Data Protection and representative of the Cypriot presidency of the Council. And last but certainly not least, Wojciech Wiewiórowski, he does not need any introduction, I guess, European Data Protection Supervisor and one of the most prominent voices in Europe when it comes to GDPR questions. Thank you all for being with us today. With that, let me turn to the discussions. I think I will join you on the panel for that. Or do we have So the EU Commission has published omnibus proposals, as we all know, which are currently at different stages of the legislative process. The proposals introduce specific adjustments affecting various elements of the EU digital acquis, including the GDPR and the AI Act. We will be discussing whether, in your view, the omnibus proposals meet their objectives to simplify compliance and reduce administrative burdens while maintaining a high level of fundamental rights protection. Ms. Kayurand, my first question goes to you. What is the state of play of the legislative process with the digital omnibus on the GDPR, and which of the proposed changes do you think will get the support from the European Parliament, and which changes should be rejected?
Yes, thank you for the question. I think the rest of the panel can leave, because answering this question, it will take at least an hour to go thoroughly through all the points. But to be brief, yes, the omnibus proposal is being already discussed in the European Parliament. As you know, our work is really confusing. The procedures are really confusing. So there are two committees involved, LIBE committee and ITRE committee, with all the shadows, yeah? And then there are two opinion-giving committees with all the shadows. So altogether, 30 plus are the members of the European Parliament who are at the moment discussing the draft. I presented my proposal to my co-rapporteur from ITRE, Aura Zalla. And I have her proposal. But I can't tell you in details, otherwise I have to kill you. Because the proposal, it will be public on the 22nd of June. At the moment, we're reading each other's parts, but I can say that there are parts where we agree, and there are parts where we don't. So what does it mean for the European Parliament? It means that our joint draft proposal will consist of the parts where we agree. And the parts where we do not agree will be presented to the committees in the European Parliament and to the plenary later as our amendments. So we're in the process. We have decided that we still need impact assessment. I've heard several times Commission saying that they're not changing really almost nothing, it's just surgical small things, but it can be also a heart surgery, yeah? So I would say that we need impact assessment, and we have instructed the European Parliament to provide impact assessment. Now, as to the aims of the omnibus proposal, I can agree to each and every word that I heard from the previous speakers and that I will hear from Renate, because I know what she's going to say. It's going to improve competitiveness, agree. It's going to improve implementation, agree. It's going to simplify, It's going to not to change anything much, but only make it more clear, not really. So, and here come the differences. No, it's not a secret. I've said it before that one of the principal questions, and I listened very carefully to Professor Talus, is on the definition. And here I share the position of the Council. I share the position of the EDPS, EDPB, that changing definition is not really simplification in the context of the omnibus. We are fighting for competitiveness, and we have to do the things where we make it easier, especially for our European businesses and from our European small SMEs. That should be the aim. But changing the fundamental nature of GDPR, that should be another process. Whether it needs to be changed or not, that's not the topic of today. But in the second part, if we reach the second part, and we were talking about fairness check, so maybe they're happy to elaborate more on that part. So 100% support to competitiveness, to less fragmentation, and here I'm saying it in Germany, because I'm receiving phone calls, emails, letters saying that there are 18 DPAs in Germany, and they do not implement or even understand or guide businesses the same way in different administrations. And that's the fragmentation. We can write lots of new laws. We can write whatever. But if implementation is not united and remains fragmented on national level and among member states, it will not improve the situation. So I'll stop here.
Thank you very much for that, Belgrade. So, Mr. McNamara, I don't have to give you back your microphone. I see you already got one. Okay, super. I have two questions for you, actually. What are the important changes brought by the AI Omnibus? And what is your opinion on the final text? The first question. And the second one is, did your experience with the AI Omnibus provide you with insights on how the digital Omnibus and GDPR proposals may develop further?
Yeah, the first one, I suppose, the major changes were the stop the clock mechanism, whereby in the high-risk chapter of the AI Act was due to come into force on the 2nd of August of this year. So that's been postponed, and it's been postponed to a definitive time, to 2 years and to 1.5 years. Because the harmonised standards which are being developed by independent bodies, since Senelec, weren't in place, which would enable AI developers to demonstrate compliance. That is by far the simplest way. It's not the only way that they could demonstrate compliance, but it's certainly by far the simplest way, and for most who are developing AI in Europe, it would be absolutely essential for them to have a way, an easy way to demonstrate compliance. So that was achieved, and I think that was the primary objective. It was because of the time frame around that it had to be, that the legislation had to be in place by the 2nd of August, that the AI Omnibus was separated from the digital omnibus, because it had to move at a considerably greater pace. The other major elements of it are, there's the issue of nudification and non-consensual sexual imagery became quite a major issue in the run into Christmas and after Christmas of last year. It wasn't new, it had been, there are many applications that were on the market doing this, but it became much more of an issue across Europe, across the world even. And that is addressed with a ban on non-consensual sexual imagery, which was proposed by both. It wasn't proposed by the Commission in their text, which focused on the existing AI Act, but it was proposed by both co-legislators, albeit with slight differences. And then the machinery directive, or the machinery regulation rather, is taken out of Annex 1A and into Annex 1B, which means that the AI Act, many parts of it don't apply directly, but will rather standards will be eventually incorporated by way of delegated legislation. They're the major components of it. There were some other Commission proposals that were slightly amended, slightly changed, but I think it's quite a different proposal to the digital omnibus, in that it was brought about by the fact that harmonised standards weren't in place. They were seen as, and I would agree that they're essential for them. You can debate why they're not in place and to what extent influence has been brought to bear in that, but they're not in place, and they were essential for developers of AI in Europe to have those in place to demonstrate compliance. The changes that are proposed in the digital omnibus are somewhat, the timing of them is somewhat less urgent, I would have thought. So the fact that there isn't an impact assessment is somewhat, in my view, less forgivable. Then the question, am I satisfied with it? I'm broadly satisfied that the protections that are, no, I am satisfied that the protections that are contained in the AI Act are maintained. And I think that's important, because I think while the digital economy becomes more important in Europe, and there's more of a focus on our competitiveness gulf with the United States, I'm not sure that our populations are any less sceptical. And I think it's important that we bring society with us. I'm not sure that they're any less sceptical about the impact that some of these changes are having on their privacy, the respect that some of the big tech companies have for when there's a choice between profit and privacy, how that comes down. And I do think it's important for legislation and for legislators to reflect those who elect them as well, and I don't see that. And forgive me if I haven't remembered or answered all of the it's not a desire to avoid answering them. They seem like reasonable questions. But
we got many answers from that. Thank you very much. Yeah, thank you. Mr. Ku, in your view, how do member states see opportunities and challenges of the Omnibus proposals? How are things taking shape within the Council? Maybe even could give us a few insights from what happened in the Council today.
Yes, of course. Oh, it's working, perfect. So first of all, thank you so much for the invitation, for having the presidency over on this panel, which is very relevant, both timely but also substance-wise, clearly. And as just a brief disclaimer in the beginning, these are just the views of the presidency, because I think we have really gotten a taste of what Brussels bubble publicity comes with. So I just want to clarify this right in the beginning. Now, as how things are going in the Council, discussions have been ongoing in the Council and have started since 2025. The discussions are very lively. We've had various AGS meetings, which is the formation that we meet under to discuss these proposals, but also under technical workshops where the presidency was asked to clarify some parts of these proposals that obviously were more technical. And really things have been evolving with a lot of hard work on behalf of the member states, which had to mobilize sometimes 1, 2, 3 ministries to really provide us with output to consider for our drafting and redrafting. And for us as presidency, really, we are very focused on moving swiftly on the simplification agenda. And as a guiding principle, we have one, obviously, to deliver simplification gains, but also to ensure legal certainty and really find this balance, which is the very challenge of the Omnibus as we see it. In the Council, between really making compliance easier, reducing administrative costs and burdens, but also respecting and maintaining a high level of fundamental rights protection and data protection, really. So, indeed, the simplification opportunities are apparent in the Commission's text, and we really see various viewpoints within the Council. So, some push for more simplification. They want more output, but there are some that are more cautious. And so these two viewpoints, let's say, along with the viewpoint that simplification should not at any cost lead to deregulation, guide the presidency when it comes to its drafting. And just to answer also the question about what happened today. So today, the presidency asked for some guidance from the political level on not only the GDPR parts of the digital omnibus, and overall there was wide support for the text of the presidency, but also with regards to specific elements of that guidance, we have had a clear route on where to move with our next text that we will keep talking about and discussing within the Council until the end of our presidency, which is not too long left, by the end of June.
Thank you very much. Ms. Nicolai, what is the Commission's view on the final text of the AI Omnibus? And what do you think on the current discussions about the proposals of the EU Commission's Digital Omnibus proposal?
Well, I would really agree with Mr. McNamara on the AI Omnibus. I think this was a difficult test because we really were working under a time pressure. And this was the test whether we achieve it in an interinstitutional process with ambition to give the legal certainty that the business deserve. Because otherwise it would have been impossible to know what to do on the 2nd of August when, normally these rules would have taken and would have gone into a direct application. I think it also showed that these matters are complex and that all sides need time to prepare their positions. So, and I think that's a lesson to learn for the digital omnibus, that sometimes when you rush things too fast, things can be a bit rocky. And that's what we saw also in this omnibus. But also that when there is a willingness to come to a conclusion, it can work. I think in general, these omnibuses, they are not normal legislative files. They are something special. That's why they are called omnibus. They are also supposed to be dealt with in a slightly different way, of course, following the structures that we have in the institutions with sometimes several committees, in the council, a special kind of working group that has pros and cons. But I think we owe it to the expectation that we all together raised. And here I talk about tripartite, also about the recent tripartite statement, One Europe, One Market, from the European Parliament, the Council, and the Commission, that these omnibuses are important, to be delivered in time, with ambition, so that we actually fulfill the expectation that we can make, the competitiveness of Europe a reality. So they are important. And so is the digital omnibus. I would say the digital omnibus is really more clearly driven by making it simpler for businesses to comply. If you look at what we do on the data side, on the data market rules, we have a complex structure of 4 legislation. They were mentioned, Data Act, Data Governance Act, and we have leftovers from the past, really no longer necessary like that. And we make out of that one data market regulation, which is the future Data Act. And we're making very good progress on that, and I hope that also in the Parliament this can be a very constructive debate. But if you want to kind of, give that signal, we mean it, that we want a data market in the European Union, then after 10 years of the GDPR, we felt it was also important to address the concern that was raised by many business, in particular small business, in particular European business, who said, well, but we are not sure we can really do this because of GDPR. So I maintain my view that it's not a heart surgery, that it is a targeted addressing some of the clearly important aspects for the pro-innovation aspect of the GDPR, scientific research and data, training of AI and data, picking up recent jurisprudence on pseudonymization and where the personal data regime ends, and that is the idea. I know that the definition of personal data, that we kind of changed that, has raised a lot of concerns, and I think we're making good progress in clarifying that there can be a way around that without kind of addressing the definition of personal data. But I think it's important to really remind us why we're doing this. We all want AI innovation in the EU. And without access to data, that's not going to happen. We can have the best cloud infrastructure, the best microchips, the best connectivity, the best AI factories. If they are not fueled with data, it will be meaningless. And that's why we need that kind of, adjustment without lowering the level of protection, building on the GDPR, but just making it a little clearer so that it's understood everybody in the same way, to what extent personal data can be used for innovation-friendly businesses. And that's important, because we need to build our own models, and for that we need the data.
Thank you very much. Mr. de Posson, what do businesses think of the Omnibus proposal? Which elements of the text are particularly important for businesses?
Thank you. Maybe just thank you very much for the invitation. A few words on the European Tech Alliance. So I represent 39 European tech champions, all headquartered in Europe, with European leadership, with the research and the development done in Europe. And I think how Renate ended is very much what we are caring about. What is today holding us back from being able to scale, from being able to succeed globally? And if you ask my members, and my CEOs were in town last week, well, the answer is very simple. It's too much regulation, too much time spent on compliance. Compliance is essential, but when a company spends 30% of its roadmap, 30% of lawyers, engineers, data product people trying to understand the law, that doesn't allow you to be competitive. Today, Draghi pointed out that we have more than 100 laws into digital, more than 270 enforcing authorities. You have 17 data protection authorities in Germany. I can go on and on. It is not sustainable. What we are calling for is one market, one rulebook, to have one future together. We want Europe to be the place to live, and we're proud to be Europeans, and I think we have amazing success stories in Europe, and we're not saying that enough. I hear Americans doing poor things and saying they've done something amazing. We're doing something amazing and we're not proud of it. So I think we can be proud of what we're doing, and we can be extremely proud of our fundamental rights. And since the beginning of the evening, I've heard the position between data and fundamental rights, but they can go hand in hand. Our fundamental rights can be also a competitive advantage, and we're proud of that. Now, the challenge is, how do we make sure that we have a true data economy that can fuel AI, that can be used in a responsible way, and at the same time, that our consumers and users have the trust and that have their privacy protected. And we are seeing that the Digital Omnibus is an amazing proposal. Now it needs to go through, and we need to have a clear definition of data protection. This has been mentioned before. Let's not change the definition. Well, for businesses, the definition that we currently have is not clear. There is fragmentation, it's in interpretation, so we need clarity. If we need to have clarity, that means change. We need to go there. We need to understand what is personal data, when does the GDPR apply, what is non-personal data, and when does the GDPR do not apply. For the simple reason, if data is important, needs to be protected, let's protect it. But if it's not, we're spending a lot of our resources, time, money, resources protecting data that should not be protected. And that's just not a good way to use our time, investment, money. So I think having a clear definition of what is personal data is key. 2, we need to be able to train AI. AI is the future. If we miss that wave, Europe will not be relevant, and then our European consumer will depend on non-European tech. That's not where we want to go. 3, we need to have a single entry point to report data breaches. If I spend time reporting 27 times the same information, that's not good use of my time and money. 3, cookie banners. Let's be very honest, we're very much annoyed by those cookie banners. But if we don't have a clear definition of what's personal data, those cookie banners will still exist. So I think it's very important that in case of .European tech, we'll still come with that kind of banners just to be safe. And today what we are concerned is having an intermediary that will take us away from our users and consumers. We've been years building trust with our users, and today we are facing the situation that maybe you have an intermediary that will explain for you how you use data. And you put it at browser level, knowing that today Apple and Google own 80% of the browser level. So no, we do not want to go through Apple and Google to be able to be in contact of our users. So we do not like Article 88B. And 5, for us, the future is privacy-enhanced technologies. It's a way for us to be able to have a data economy that is privacy-enhanced. I'm going to be honest, there is pets bashing, of course. But then what we expect is to have standards from the Commission that will explain us which kind of privacy-enhanced technologies can be used, how they can be used, so that you're sure that you overcome that pet bashing, that will not exist anymore. Plus, those standards will enable us to have fair standards and fair competition. I very much do not want to end in a situation where one of the American, Chinese, whatever, comes with, pay me 1,000 euros and you'll comply. No, that's not what I want. I want my companies to be able to compete with those giants. So I think if we enable privacy-enhanced technologies with standards from the Commission through Article 41A of the GDPR, we'll end up there. So I think that's how we end up with one market, one rulebook, one future, where data economy can exist with a privacy-enhanced framework. And as European tech, we're very happy to bring the real brand experience on the ground, but we cannot continue to being taken between different interpretation and so many enforcing authorities having so many different interpretation of a single text. Thank you.
Thank you very much. Mr. Hartl, looking at the Omnibus proposals, what are the hopes and challenges from the perspective of a national data protection authority there?
Thank you. And first of all, let me, being representative of one of the co-hosts, welcome you all. I'd like to welcome colleagues and representatives from EU institutions, supervisory authorities, civil society, and industry. And let me also appreciate the effort of the Commission, of the co-legislators currently, especially the Cypriotic presidency, in their hard work from my previous tenure at the German Federal Ministry of Economic Affairs, being in charge as a lead for AI Act, Data Act, and Data Governance Act, and many more. I know what hard work it is, so thank you very much. Now, speaking as a DPA, to me it's really encouraging to see how many of the recommendations from the joint EDPS opinion found their way into the negotiations. I think this is really remarkable, and I think in hindsight motivates us to keep track with what will happen. And I truly hope that the member states and the parliament will build on this statement even more and achieve more progress and reach an agreement swiftly. Now, the clear message my Commissioner Luisa Specht, Riemschneider, and I have is we support the objectives fully. Reducing administrative burden, simplification and harmonization is also something what Anu pointed out was one of the core ideas of our Helsinki statement previous year, or to put it more bold, GDPR made easy. We as DPAs really are not opposed to making it more simple. But what's really important, what Anu also pointed out, is that still rules have to serve fundamental rights, not undermine. And what is also part of our position is very clear, to keep the substantial level of the protection. We're also not opposed against a strong competitiveness. We think that competition has to serve the common interest, and as it does, it's very welcome. And of course, we would also see a strong competitive European manufacturers and producers, and to support them in developing products from Europe. And the big thing, enhanced legal clarity. I mean, we have to work on a daily basis with the legal, with the laws we have, and have to we are in contact with citizens, with industry. So we are fighting the fight daily, and we would really like to see more clarity, not only for us, but for all the parties that I mentioned. And to make also one clear statement, because sometimes we hear that GDPR is an enemy of innovation. It is not. Legal uncertainty is the enemy, not data protection. So on your question on hopes and challenges, so I know I don't have 1 hour for my first intervention, but I mean, what are we doing? We want to see a situation where we have rules being complied with. So, or as GDPR puts it, monitor and enforce the application. So, and again, what is necessary? As I said, clarity and on rules. What we really appreciate is the harmonized definition on scientific research. I think this is a big step. On AI training, we would like to see a more comprehensive rules on legal basis, because we also see the importance of data for AI training. And there are some issues that should be dealt with, and we need practical solutions for data subjects' rights in an AI world. So what does right to erasure actually mean when that when erasure would mean to delete a whole AI model because of technicalities? So I think we have to rethink this. We discussed this in the German conference of DPAs. We made proposals, and we're really looking forward on the progress, and I think we are happy to support with ideas. Next step, procedural relief. What we like to see, or what we appreciate again, is that the threshold for risks for notifications has been lifted. To be honest, being a representative from Germany, we would have liked to see the wording more than low instead of only high. I think only high leaves out a lot of still important breaches, but we fully support the the position we found together. I think also single entry points are important and common templates for data protection impact assessments. Then what was said, also hopes and challenges, coherence with other legal acts. I mean, we're currently working together with other authorities in Germany on the Digital Services Act, now Data Act, and this interplay is a major issue because what the Commissioner, I see the point, said is, well, we have the GDPR and we don't touch it. But in practice, I mean, companies only have one process for giving data to their users. And there might be some challenges when you compare GDPR and data. Maybe we come to that later on. The proposed rules on cookie banners, also another good example. We see the point, and we also would like to see some clarification and simplification, but to have now another legal act with rules on the same thing. So having the e-privacy and the GDPR alongside, I don't know if this really gives clarity in practice. Then one wish, complaints handling. We see really like a hockey curve when you look at the complaint numbers. In many cases driven by AI. Now complaints are very important. We started as authorities where you could complain as an ombudsman, ombudswoman. And this is very important. At the same time, we have to deal with it. We have to be able to maybe focus on the really important issues. So, and I think we should also have an open discussion on the management of complaints. Now, since we're talking about opportunity, I would also like to address what, in a way, is missing out at the moment. Addressing structural imbalances in the digital ecosystem, especially between large technology providers and the many SMEs we have throughout Europe. It was mentioned also by State Minister Joachim Herrmann, the manufacturer responsibility or producer responsibility. This would really give ease to SME companies who are in the position of controller or processor, but actually don't have control of of the product they have bought. Then another striking issue, the growing threat that is posed by commercial data brokers, where we have practical issues to address them. And final point, the protection of children's personal data, we think remains insufficiently addressed. We are working on that in the G7. We, as the German conference, made proposals. And we think that there would also be some leeway to improve the situation of minors there. Thank you.
Thank you very much, Mr. Hartl. Mr. Wiewiorowski, what are your hopes and challenges looking at the Omnibus proposals?
Okay, maybe this one will work. Thank you very much for the question, although most of the answers have been given by Andreas, because there's not that much difference between the point of view of the data protection authorities on the national level or even on the provincial level in some countries and those on the European level. Maybe we are a little bit more focused on the problem of harmonization and the lack of fragmentation. Although on the other hand, we have to say very openly that was the conscious decision when the GDPR has been created, that there will be, that the enforcement of the GDPR shall be as close to the person as possible. That people are not interested in the decisions which are taken hundreds of kilometers away if the case is actually local. And most of the cases that we are dealing with are even not national, they are local. So the data protection commissioners know quite well that despite the interpretation shall be harmonized, interpretation shall be the same and fragmentation is wrong, we have to take into consideration the local situation and local culture. The transparency culture that exists in the Scandinavia is different than the transparency culture in the other parts of the Europe. So this is not a surprise that a decision like that has been taken 10 years ago. We are now rather rethinking, is it right? Or what are the problems that are going out of that? So I still treat the whole Omnibus exercise as the exercise in targeted changes, adjustments, not the changes of principles of the data protection or principles of the enforcement even. So I would be very happy if we will keep the focus on these things that were proposed by the Commission and not to throw the new things to the discussion, because that looks a little bit sometimes like the genie out of the bottle. We are just opening some bottle in order to find out that there are many questions that we have to ask ourselves before we will start to give any kind of answers. That was very well visible in the discussion about the definition and the change of the definition, which I was quite clear from the very beginning that for EDPS it's a red line. We shouldn't touch the definition because that's the definition of the notion which is in the treaty. And it has to be taken globally and with the whole history and all inventory that we had so far. You cannot take one judgment, even if you agree with it, and change the definition because of that. So in this sense, the proposal of the definition was not good, especially that the judgment that was the Commission tried to petrify was actually rather about pseudonymization. So maybe the discussion, if any, shall be about pseudonymization and the meaning of this notion than the notion of the personal data. Because it doesn't answer the question that you presented as a business question, that the notion of personal data is not clear enough. That is just a piece of the discussion that was touched here. But what is the most important of what Andreas said, there are the parts which we absolutely agree with the Commission, or which appeared during the discussion and seems to be supported by the data protection authorities and by EDPS as well. The DPIA, the best example, as well as the data breach notification centralization, or rather not centralization, but streamlining of the data breach notifications, but also e-privacy changes, and what was, I have to say, a little bit surprise for me, scientific research. With scientific research, the data protection authorities were quite strongly calling for having the same the definition all over Europe. But to be frank, I didn't believe that the countries will want to go this way. And here I have to say that that was a very good work from the Council, that this proposal have appeared again and start to be discussed. So that would be the most important points, and I would say once again that I hope that we will stay in the line of making the clarifications of what we have in the law, or the adjustment changes in the text of GDPR and probably the other parts of the digital rule book, not going against the principles of these acts.
Thank you very much. So this was the end of round one. To quickly sum this up, everybody here wants simplification and legal certainty. Nobody wants heart surgeries. But I'm wondering if even the definition of personal data, the main concept of the GDPR, is considered as heart surgery on the one side and simply a way to clarify a very essential legal term by the other side, what that means for the next steps and for the trilogue. But we remain confident that we find common ground here and that we satisfy the needs of all the stakeholders in the future. So we are entering round 2. The Omnibus proposals addressing the GDPR and the AI Act represent only a first step towards modernizing the EU digital legislation. The EU Commission is already looking at further simplification efforts and undertaking a stress test of the digital rulebook, also known as the digital fitness check. This exercise focuses on the interplay between different elements of the EU digital rulebook and their cumulative impact on businesses. So we will be discussing what should be the strategic priorities in the coming years to ensure digital innovation and competitiveness within the Union while preserving the protection of fundamental rights. So, Ms. Nicolai, which further simplification efforts and next steps is the Commission contemplating while conducting the digital fitness check?
Well, the Commission is answering the call from the other institutions, really. I mean, there isn't any European Council that doesn't call for stronger measures on simplification. What is true is that in our digital area, our Executive Vice President has from the beginning said that we would do a fitness check of our entire digital acquis. And that's what we are rolling out. So of course now our focus is on finishing the digital omnibus with the level of ambition that we have put in our proposal, so that it really simplifies the work and the business reality. But we have already launched a public consultation on the fitness check, and we are at the moment crunching the numbers of the several hundreds of contributions that we got. And it's a bit too early to give you the fine print on what will be next. What is clear also from the discussions that we heard here today, that the kind of how the different rules act in coherence with each other is a challenge for everybody. We are proud of our digital rule book. I think we did the right thing to have a single market approach and to have one single digital rule book for the entire single market. But of course, with the DSA, the DMA, the GDPR, the AI Act, there's a lot. And so I think one area could be for how can we facilitate a better coherence between the different kind of, governance structures, and also between the overlaps that are inevitable between the different acts in a very dynamic digital revolution that we are witnessing. Because that's the additional point when you're regulating in such a dynamic place such as digital transition, you have to be inevitably principle-based and leave some space for co-regulatory adjustments to really kind of live up to nudity apps appearing or whatever kind of developments we might see, or mythos now on AI and cybersecurity, to give 2 recent examples. And in order to cater for that, I think that's an important coherence work. And then there are, in our digital rulebook, some acts that we haven't touched on in these 2 first omnibuses, because we wanted to go for the most evident. We did implementation dialogues, we did assessments, we have a very thick staff working document that came together with the digital omnibus and the AI omnibus. That kind of is a testimony of why we chose this, but there's of course other acts that we want to look at and to see is there still something that we can do to simplify further. But what is clear is that we want to first finish our digital omnibus that we have on the table now and deliver on that before we embark on other things. But also this is not going, without the context of the Commission that has, with the general services, started a deep cleansing exercise. So all the commissioners are really called upon to look critically at their acquis and to see what else could be done to lower the burden of businesses. Because unfortunately, the feeling remains amongst European businesses that it has become rather hard to kind of find your way through this regulatory jungle. Some of it, I think, can also be facilitated by us simply giving more guidance. If I take the example of the Data Act, another very fundamental act that is more an enabling act for data access and sharing of data, I think there's more to be done to actually give a helping hand an effective implementation of the Act so that business can better understand what we mean and we can facilitate business solutions. So it doesn't necessarily always have to be also only regulatory, it can also be other measures. But we will engage in this discussion, of course, also do this together with the sectors and then come up with something. But once we have the digital omnibus home.
Thank you very much. Ms. Kaljurand, which changes or clarification to the EU Digital Rulebook are required in your view, in particular to ensure a workable interplay between the GDPR and the other acts of the digital acquis?
Well, thank you for the question. I'm a former diplomat, yeah? Which means that you listen to the question and you say what you want to say. But if seriously, when I listen to the discussion here, we're talking about single market. But let's look around. There is no single market. We're talking about digital single market. We've not been able to introduce pan-European digital ID. And I'm saying it also in Germany. I was negotiating that file, and I was hearing all the time how it was impossible because of German constitution. So what I want to say, we can adopt I don't know how many laws, but if there is no political will to act as one single market, it will not change. I'm come from Estonia. I had the privilege of having online services, digital services for almost 30 years. And I don't want Estonian startups to go to the United States or other countries. I want them to go to other European member states, but they don't. Because the bureaucracy is there, the walls are there, it's so difficult to start a business in another European member state. So we can adopt I don't know how many laws and I don't know how many rules, but as long as we do not change the understanding that we want to have single market to compete with the United States, to compete with the rest of the world, it will not change. I'm looking forward to the fitness check. I'm really looking forward. Because when I said that GDPR has to be, well, how to put it, has to be analyzed and maybe changed. I do not exclude that. But it has to be done in a proper process. It has to take its time, and if it has to be changed, we'll change it. And I think that the fitness check is exactly the place where and how we can do it, and look also at other laws and regulations that also were mentioned also by Renato. Do not exclude that. But we can't do it with the Omnibus. Now we're going back to Omnibus, yeah? That's another procedure. That's something that we have to do immediately on competitiveness. So let's not change all these things and let's not put them into the same pot. At the moment, competitiveness, longer perspective, let's look at the laws and regulations and change them. But to change them, we need the trust of our people. You can introduce I don't know how many digital rules and laws. If people don't trust, they will not take it. They will just not do it. So it's very much also the question of trust of EU institutions, but also of local governments, of member states' governments. It's very much the question of trust. So what I want, I also listened how difficult it is to implement the same laws in the same way. I'm a lawyer by education, and sorry guys, I do not understand. If there is a law, we have institutions who interpret them, and the interpretations are out. There are guidelines out. If you do not agree, change them, argue, but once you agree, that's the guideline, start implementing it. And as long as we're just, the DPAs are arguing among themselves, member states are arguing amongst themselves, nothing will change. And I'll make my last remark. I'm a politician, yeah? I'm a new politician, I'm a virgin politician. For the rest of my life, I was in Estonian Foreign Service, so yes, I'm not a professional politician. And maybe that's why I do not speak like a politician. But I would like to ask politicians not to make always political decisions. I listened to what you said about minors. And I see today how huge there is an appetite, for example, to ban social media for kids under 16. Because if you talk to somebody, do you love kids? Yes, I do. Do you want to protect them? Yes, I do. Let's ban under 16 let's do it. So I want also politicians to think before they agree to something which is very good on a slogan level, but which might have completely different implications. And banning social media for kids under 16 will not work. Look at your own kids, look at your own grandkids, they are much smarter. So let's not do political things. Let's do things that are really useful, that are beneficial, and that really bring some change.
Thank you very much. Mr. McNamara, similar question to you. So, which changes or clarification to the EU digital rulebook are required, in your view, to ensure a workable interplay between the AI Act and the other acts of the Digital Act?
I mean, obviously we have to look at training of data. I mean, and we also have to look at the reality of what's happening in the world. I mean, it's important that we protect fundamental rights in Europe. It's hugely important. But I suppose we have to look at the competitiveness side of it, and we also have to look at what's actually happening where data is being used Europeans' data is being used to train models, whether we like it or whether we don't. So I suppose we have to look at that reality, and that is something that will have to be addressed. But equally, I mean, what I hear a lot from companies in all sorts of areas is frustration with fragmentation. And while I heard what Professor Wiewiorowski said and the reasons for the choices around how the GDPR is to be applied, I think we're going to have to look at whether it's working or not. And if it's not working, well, what are the solutions? I mean, is the solution a big centralized body in Europe? But if it's not, then what are the solutions? Because we can't simply have, just I suppose I sound like I'm repeating what my colleague Ms. Calderon said, but we don't have a common market, and that is the biggest obstacle. I think companies, from what I'm hearing from them, may or may not like the GDPR, but what they most want is certainty. What they don't particularly want is more changes that will be interpreted differently in different member states. I was one of the many in the Parliament who worked on the GDPR procedures regulation. It spanned this mandate and the previous one. I don't know how that's working out in practice yet. I mean, I know that it comes into force in 2027. So if you're carrying out a fitness check now, is that fitness check going to take account of it? Is it not? What impact is it having now? But I mean, there is companies need a degree of foreseeability in what they're going to be told by regulators, and we have to do. I think that is paramount. I don't have an answer as to how you achieve that. I was somewhat surprised, I suppose, when there was a call for evidence in the Omnibus that was implicitly excluded. I am a little bit sceptical about the interplay between, I have, the AI Omnibus had to be done for particular reasons. You might not like the reasons, you might be sceptical about them, but most accepted, or most in the Parliament accept that it had to be done. I'm a little bit sceptical though about this interplay between the digital Omnibus and a digital fitness check and more legislation that will follow. If the problem is uncertainty and too much legislation, then this rolling legislative model, which seems to exist in Europe, is perhaps not the way to respond to that.
Okay, thank you very much. Ms. Tsoku, from the perspective of the Council of the EU, what are the priorities to ensure a smooth interplay between the various EU digital laws while maintaining a high level of data protection?
So thank you again for your second question. The topic of a smooth interplay between the laws in the EU's digital landscape and also the need to maintain a high level of data protection is really not new for the Council. You may remember that in November 2023, the Council adopted its position and findings on the application of the GDPR prior to the Commission's evaluation. And in this position, basically the Council recalled the need to ensure consistency and really prevent fragmentation when it comes to the EU digital laws landscape and the protection of personal data specifically. So now from our experience currently and in the context of the current discussions, we've certainly noticed the importance of evidence-based legislative work, which such evidence can really facilitate convergence, and it can really guide when it comes to initiatives that aim to streamline this framework further. And throughout the last few months, we have received a lot of comments, a lot of pleas from different types of companies, of organizations, and at this point, I think it would be good to highlight the importance of ensuring this input is maintained in any future efforts to streamline further, be it from the private sector, from companies, but also from consumer rights organizations or civil rights organizations, NGOs, academia. So indeed, the integration of consultations is central to this process. And the main message is that we would like to see that the GDPR is really ensured as a cornerstone in this process, that can really smoothen out the interplay between the digital laws while also upkeeping, again, a high level of data protection. And maybe another point is that we should probably look at further at questions of governance, of enforcement, of interpretative powers amongst different competent authorities. So yes, we consider that all of these elements can really contribute to this very consistent and effective enforcement of different laws within the framework and can really guide the way forward when it comes to new initiatives.
Thank you very much. Ms. De Posson, from the business perspective, what should be strategic and practical priorities in the coming years to ensure digital innovation and competitiveness in the EU?
I think for us it's very important that we go from a jungle of regulation that we face today to a puzzle that clicks together. We very much would like to be able to compete globally and not only comply locally. We would very much like to see the European institutions support all the European entrepreneurs and not only thinking about SMEs. If I have to think about some German of my members, Get Your Guide, Zalando, HelloFresh, Trivago, AirHelp, these are all amazing German success stories that made it, and that was to be able to support and be able to be successful globally, and we're proud of their success. But we need to go beyond only helping SMEs. We need to be able to help all the European entrepreneurs. If we have one wish for the digital fitness check, and I can tell you that our consultation input was more than 25 pages long. I wish good luck with the 700 consultation that you have to go through. One message is better coordination with enforcement, and that means that within one member state, Germany might be a good example, that you need to have enforcing authorities working more together, cross-sector, so data protection authorities working hand in hand with AI authorities, with innovation authorities, with consumer authorities, with competition authorities, and I can go on and on. Member states working more together and having the European boards together. We're brilliant at creating AI board, DSCs, ECN+, EDPB, I can go on and on. We need to work more together. And that's really how we will create one market, one rulebook, and one future. Thank you.
Thank you very much. Mr. Hartl, what is your view as a German data protection authority with regard to the EU AI Act and the EU Data Act? Is there a need to enhance the interplay of these acts with the GDPR, and what needs to be done there?
Thank you. First of all, I would like to clarify one point. Madam Cagliaranti didn't say so, but just to make clear, my position is not to introduce a ban on social media, not as a private person and not in my position I have. This is a question for politicians. If there is a demand for a ban, it has to be GDPR compliant. That is important for me. Now, on your question, and maybe just one example for what we mean as the German conference, when we think about more protection of children. For instance, the consent under Article 9, letter A, in para 2, it would also be open for minors to consent. Maybe it should be restricted to adults to consent in that. So that is one of the proposals we made as the German conference. On your question to the interplay. Regarding the Data Act, I see two clear priorities. One is the maybe a bit more ambitious use of GDPR opening clauses. The GDPR already allows for building a coherent and consolidated digital legal framework, and we see that, for instance, in the AI Act, there in Article 10, there is a legal basis for processing of data. So maybe there could be more clarity in the Data Act when sharing personal data is mandatory or prohibited. Maybe it could be a bit more, executing the legitimate interests on a legislative level and not to leave it to the controller, processor to determine the legitimate interest. I think legislators are also there to determine the legitimate interest. So I think that could be one of the trajectories. Another question would also be maybe to give more clarity who qualifies as data controller. Now, the GDPR knows in principles the controller and the processor. The Data Act knows the data holder and the user. Now, I once went to an event from the car manufacturing industry, and they told me that there might be, 9 different entities under the Data Act who qualify as data user, and who of them actually qualifies as controller when you put together, or when you have both legal acts next to each other. So I think this is really something where we have a lot to do now in the execution, and we would like to internalize the issues. We don't want to externalize it to the industry, and this is something where we really have to motor up as authorities. But this brings me to my second point, to ensure an effective formal cooperation between the authorities. Of course, we have informal contacts, but for instance, rules on information sharing, including trade secrets or personal data, if we would have more clarity in the legal acts, how we can actually forward data, how we can formally work together with institutions executing other legal acts, this could also help in practice what we are allowed to do and what not. On the AI Omnibus, first of all, I would also like to appreciate the produced agreement. Again, I know how hard it is to find an agreement. Yet, and I mentioned it already, there are still some crucial areas when it comes to fundamental rights protection, especially when it comes to the development and training and operation of AI systems and body. I think there is some room for more clarity. I already addressed the issue of right to erasure and the question of proportionality. If right to erasure would mean to delete a whole AI model, which has been trained with a high investment and under high costs. Also, questions of access, information, transparency. I think we together have to find, in a way, adequate ways to have those very important rights from data subjects, and to find a way how this could be done in an AI world. This is very important for the protection of fundamental rights, not only from the data subjects, but also from the companies, who also have fundamental rights. And for us, it's about balancing fundamental rights as it is for you. Thank you.
Thank you very much, Mr. Hart. So last question for you, Mr. Wiewiorowski. From the perspective of the EDPS, do you see a need for further legislative action regarding the interplay of the different EU digital laws? And what should be the priorities there?
We might say that in the short term, priorities should be the consistency of the changes that we do. Because with omnibuses, we start to change a number of legal acts, sometimes forgetting that there are the others which shall be also coherent with them, where we are talking about changes in GDPR, forgetting that there is a law enforcement directive which shall have the same vocabulary. We are forgetting about the fact that there are the legal acts on European level about the use of data in the EU institutions, but also about the special agencies that are dealing with the data, the special information systems that exist there. So in the short term, that would be also the consistency in the changes that we do. In the longer term, definitely the question of the interplay between the parts of the digital rulebook will be coming back, although we have to first use the possibilities that are given now. Possibilities that are given through the work of the AI board, through the work of the high-level group on Digital Market Act, also EDPB, and the cooperation between the EDPB and the Commission in preparing the common guidelines. This should be the first round of the interplay. But I'm not excluding the need for the further changes in the legal acts which create the digital rulebook, and I'm somehow ready for this discussion. I'm not going to go with the banner, I want to change GDPR, because this is not exactly the role of the European Data Protection Supervisor. But if you ask me, are we ready for this discussion? Yeah, we said 2 years ago, brace, this discussion comes. And if you want to discuss the definition of the personal data, well, I don't think that's the most important discussion to do now, but if we want to do so, then my question is, are you ready for the discussion about identifiability? Do we know what does it mean to identify somebody? Do we know what singling out means in all these systems that we created so far? These are the questions to be asked with those that we are asking in the Omnibus. And then you have to have the impact assessment, you have to have the discussion which is broader and better prepared. But I'm also ready for the fact that the political agenda will be adding additional subjects to be discussed. And let's be frank, that happens. That happened with the changes to Omnibus on AI, where there was also one discussion which started to be political during the procedure, and it came as a change to the legal act as well. So consistency, fight with the fragmentation, but also readiness for the discussion. Is our model that we prepared throughout the years the best? Because I remember still the representative of the industry who at some point said that the definition of hell for him is the European law with American enforcement. And that is something to be remembered as well.
Thank you very much. So we open the panel for questions. Are there any questions from you in the audience? Yes, please. Gentlemen, here. Yeah.
Well, my name is Dieter Kugelmann. I'm a state commissioner in Germany, Rheinland-Pfalz. So I'm one of these 18 guys hindering innovation. So my remark goes to you, Ms. Karimas. There's no no serious fragmentation in Germany about the interpretation of the GDPR. We have established well-working structures. We do our very best. We're not perfect, but it works. It works in general. In my land, Rheinland-Pfalz, we have 4 million inhabitants, 200,000 companies, and well, actually, that's where it works, and I don't see a real problem. So you can lean back and have no sorrows about that. With the rest, I absolutely agree to all you have said. My question goes to Mr. McNamara, because I'm also head of the working group on AI of the German conference. In the digital fitness check, do you see a chance to, let's say, enrich the product safety approach of the AI Act? Because it's only about the product AI system. Is it perhaps too limited? Because we talk about intellectual property, we talk about ethics, especially talked about what Andreas Hartl said about individual rights. How can they enforce in times of AI, perhaps in the GDPR? But do you see there progress made, innovation and fundamental rights, if we, let's say, move a little to a more general approach and not cling too strictly to a product safety approach? Thank you.
Mr. McNamara, I think this was directed to you.
Yeah, thanks. I mean, do you mean like product liability approach and greater certainty around that area? Well, I have to say I don't expect to see a commission. I mean, obviously it'll be the commission will propose legislation, and I don't expect, but I mean, you're probably asking the wrong person, but I don't expect to see a proposal from the commission in that regard. For, well, 2 reasons, I suppose. The first is because there was a proposal for an AI liability directive. I think it was a regulation. I think it was a directive, which was withdrawn, and it was withdrawn about a week after J.D. Vance, the American Vice President, spoke at the Paris AI Action Summit, as it was called. We moved from safety to action. And he, of course, criticised regulation. He was very heavily critical of regulation in Europe in the AI space, and that it would sort of strangle innovation, etc. And about a week later, this proposal was withdrawn. Now, that, I mean, causation, correlation, I'm not saying one or the other, but it was withdrawn. But I mean, I think, you know, but to be fair, one of the main reasons it was withdrawn was it was already blocked at council level. There was considerable disagreement at the council between member states. So for those 2 reasons, I mean, this idea of AI regulation, notwithstanding the fact that I think that the White House, the current administration, has changed their approach somewhat in response to mythos that Renata mentioned, and I think maybe a grudging acceptance that some regulation is necessary and there is some degree to which the market can't be entirely left to its own devices, and that we do need, somebody does need to step in to protect the public. But for the 2 reasons that I've outlined, I don't expect to see anything around product liability. That said, I mean, there are huge questions. Everybody's now talking about agentic AI, and I mean, it's a really interesting question. At least, do we apply? Is it going to be left to the courts to determine this? If it is, will it be determined this side of the Atlantic differently to the other? And are we going to use the normal rules of agency in something like this? Because if we are, it's fairly difficult to see how there's going to be a lot of development. For me, it's difficult to see that it's going to be so risky for developers that I'm not sure that the normal rules of agency is going to encourage innovation. Do we want to? I mean, these are philosophical questions and ultimately questions for society. I mean, do we want somebody to be responsible if an AI agent goes wrong? And if so, who do we want to be responsible? I mean, is it the normal rules of agency? Is it not? So while it's a big area, I don't see the Commission proposing it, but I'm open to contradiction from Renata on that. Thank you.
Thank you. Are there any other questions in the audience? Yes, please. The lady in the black jacket.
Hello, so I'm representing national medical associations across Europe. Thank you very much for the debate. We very much support maintaining current safeguards in terms of the General Data Protection Regulation, especially in relation to personal data, and because we have facilitated access to electronic health data with the European health data space. So this would have a huge impact also in that legislation. And on that point, I had also two questions. One was in relation to the legitimate interests. So we are introducing in the GDPR legitimate interests to train AI, but in the European health data space, this is only allowed for scientific research purposes. So how do you see this compatibility? Because if we have easier access through scrapping on the internet, having access to health data, why would you use then the European health data space to have access and train when you can use the GDPR? And then my other question was for the Parliament. You are receiving a lot of comments from national parliaments. How are you taking those into consideration in your report? Thank you.
So who do you want to start answering the question?
For data protection, perhaps data protection authorities and the council, that would be great.
Did I get this right? You want some Mr. Huh? Okay.
So, I mean, I think the health data space is in itself a big achievement. And to say in this very specific area of sensitive data, health data, sensitive data, to kind of, there have a clarification what can be used for scientific research, I think was quite an important gateway issue. And we are seeing it depicted when you're seeing the ecosystem that is building around the health data space with the health kind of, companies and the AI possibilities that this is gaining ground. What we are discussing in the digital omnibus is slightly different. We want to kind of build on the good work of the European Data Protection Board that has produced guidelines saying that you can use the ground of legitimate interest for the processing of personal data for the purpose of training AI models. That's there. It's just not implemented in the same way everywhere. That's why we felt there's for legal clarity and for a signal also, would be good to codify that in the digital omnibus. So this goes much further. This is about using personal data for AI training. Of course, you have the other legal grounds for processing, like consent, but in practical terms, to kind of make clear that legitimate interest for the purpose of training of AI models could be quite useful. And it's not a carte blanche either, because everybody who knows a bit about data protection knows that the test that the European Court of Justice has put on legitimate interest is not trivial. So you still need to do a balancing act. But I would really differentiate that from the clear signals that we gave on a health data space, which was really a gateway issue at an important time, in Europe.
Mr. McNamara?
Yeah, no, there's just one other aspect to this with regard to medical data and medical devices, and that's obviously there was the Commission didn't propose making any changes to the annexes, this Annex 1A to 1B. It became quite a politicised issue in the end. I suppose the centre right and parties to much of my own political group and the EPP and practically everybody to their right favoured moving this Annex 1A into 1B so that it would take it outside of not the prohibited practices part of the AI Act, but almost the entirety of the rest of it, unless and until it was, requirements were introduced by way of the delegated legislation. Ultimately, the compromise agreed was that the machinery regulation only would move, but there is a Commission proposal in the recast medical devices legislation to move both the medical devices and in vitro medical devices out of the AI Act, which would remove some of or could potentially, depending on what safeguards were put in place, could remove some of the safeguards of the AI Act for the processing of that type of data. So it is something that's still very much a live issue and one for debate. Interestingly, I suppose, given that it is data and given that there might or might not be a civil liberties justice sort of element, civil liberties element to this, it is not being considered by the Libe committee from a fundamental rights perspective. It's only being deliberated upon by the health committee in the Parliament. However that happened, I'm quite unsure, but that's the state of play. So there isn't going to be a huge amount of scrutiny in the Parliament from a fundamental rights perspective. Thanks.
Thank you.
Maybe that's a good thing for businesses. I don't know, but nevertheless, it's what's happening.
Any further questions? Yes, please. I see a hand here in the background.
Thank you. So this is now a question from the very back of the room. So Matthias Hilarius, I'm the Group Data Protection Officer for SAP, the #1 software provider that Europe still has. And let me put it this way. I'm very glad to see and to hear that you see that there is a relation between regulation and the complexity of regulation on one hand and competition on the other side. What I'm missing a little bit is the impact of not just the complexity. So you're trying to make rules easier. You're trying to make to take bureaucracy away, but just also about let's say the strictness, how strict the rules are on competition in itself. There is a reason why development, innovation does not happen in a global company in Europe anymore. And we see that for the entire industry. We see that for the global competition, why it happens in other parts of the world. And based on that, I can say there are some moments in the past where I say I saw a little bit light at the end of the tunnel. The SRB ruling was one of them, and also the discussion about the definition of personal data. So if you are all much more into preservation of the current standards, and Mr. Hartl, I heard you very much that you say you need to balance that against other fundamental rights, so thank you for that. I wholeheartedly agree with that. But you also need to balance that against the overall interest of society in basically getting along and being competitive in the world and not lacking behind here in Europe. If I hear all of that you don't want to touch the definition of personal data because it makes things more complex, more insecure, and you see that that's so much of a relief for the industry overall, then my question to, I don't know who started with that over here, is, and that's maybe to the entire panel, would you at least uphold the SRB ruling as a minimum standard? Thank you.
Uphold. So who wants to pick up on that on the panel?
I can do that because the intention was always to codify the SRD ruling and to really give clarity, take that very welcome clarification from the European Court of Justice on where's the end of pseudonymization, hence where's the end of the level of protection as personal data, and to give that clarity to the world in a law. That's what was our intention. So I think, and this is I think what I saw in the panel emerging as an idea, we have done it in changing the personal data provision that I think is kind of a challenging discourse in both institutions. So, you know, we are willing to kind of keep that spirit because that's what this is really about. Give a signal for the innovation-friendly aspects, and I think then we can maybe find a way.
Mr. Wieruski?
Just a few words from our side. That was EDPS who was on the other side of the barricade with the SRB. And I may say, I think that that was one of the most important judgments, also impacting the way how we understand the notions from the GDPR. But as I said before, this is rather about the notion of pseudonymization and pseudonymous data. And if we want to have a discussion on the SRB, on the good parts of SRB judgment, let's do it first of all, not cutting the other parts, because that was not what was proposed was not the whole SRB judgment. And let's do it thinking about the pseudonymization where it actually belongs. Somehow I'm happy of this interpretation from the court, which at the same time has a big impact on our previous decisions as EDPS.
Mr. Hartl?
Yeah, thank you. Just first of all, thank you for the question. Just complimenting what Wojciech said. In the European Data Protection Board, we are currently working on guidelines on anonymization, and we are preparing a document also for a public consultation. So I think it will be very important that you have your say when the board will publish that paper in this issue. This is a very crucial issue. This is at the heart of data protection and the execution, and it's very important, as you correctly pointed out. We see the importance. We're working on it. We set up a sprint team, and I just want to say that maybe this is also one of the progresses we achieved previous year in Helsinki, that we are trying to involve stakeholders at a more early stage in taking decisions of the board. So, and hopefully this will be taken up by stakeholders from civil society, industry, and all across the board to support the board in taking important decisions under a clear factual basis. Thank you.
Thank you. I think very good questions for us, the European Tech Alliance and European Tech. We very much see a benefit of having pseudonymization, anonymization, among others, as privacy-enhanced technologies being used. What we regret today, and we see an opportunity with the Digital Omnibus, is to have this privacy-enhanced technology more framed and incentivized. Because today you can use them, but you have no legal certainty that actually this means that you can use them and protect the privacy, but at the same time, this means, thanks to the RCB, that maybe then you can lighten the cost of GDPR compliance because you cannot retract them to the individual. So what we would like to see is to kind of have really the Digital Omnibus incentivizing the use of pseudonymization and anonymization of others as privacy-enhanced technologies, and frame that through standards and guidelines from the Commission, and those standards could be developed hand in hand with the EDPS and other authorities, so that we ensure that it is truly privacy enhanced, but at the same time enabling to have a true data economy, so that we have a true single market and a true ability to use AI and train AI and be competitive globally. And I think that's very much what we mean when I said we want to compete globally and not only comply locally. Thank you.
Mr. Tukus, you wanted to add something?
Yes, so also just to kind of chip in with the how it's going, also when it comes to the Council, actually the Presidency has really seen that this has been an element which, rightfully so, has gained a lot of attention in discussions within Council, and we realize, as EDPS has said, that this is an issue of pseudonymization. So in this way, we've tried to proceed forward with a text that would address these issues and in how applying these security measures can really aid in ensuring compliance with GDPR. But in terms of the change of personal data, I think definition, I think it was already made quite clear that this has been quite a red line. So yes, that's the state of business now.
Thank you very much. You want to say something?
Yes, thank you. Very briefly. Here, others explained the court case. I can only say that even the court, if I'm not mistaken, said that that case should be seen in the context of that case and should not apply to all the other cases that might come later. So even the court said that. But I wanted to say, when you said that the SMEs, they have problems with the GDPR, if we think about the Letta report and Mario Draghi report, they did not mention GDPR as an obstacle. Obstacle is single market and financing, yeah? These are the main obstacles of competitiveness in the EU. So I don't, like the hearing said, I don't think that innovation and GDPR are on two different sides. They are on the same side, so I really do hope that with all the fitness checks, we preserve our understanding of protection of personal data, the principles adopted in the GDPR. I really hope that we will not change the very principles that have become global golden standard, but where we have to improve its single market, its financing, its banking union, its financial union, whatever you call it. There's the problem. That's the reason why Estonian companies are not coming to European countries.
Thank you very much. I think we can take one final question, because we have also speakers waiting. But one final question. Anyone? Okay, there's one hand here.
Just very quickly, my name is Matilda. I work for the EPC, the European Publishers Council. Just on the timeline, Mrs. Collier, and you were mentioning earlier that you're planning on having your report on the 22nd, but you also mentioned that the Parliament's been asking for an impact assessment. So I was wondering, once you've put out your report, are you going to wait with the committees until the outcome of the impact assessment is going to come before you can carry on with the amendment and the process? Because that would, from what we see in the discussion in the council, there is a lot of call for an impact assessment to make sure we understand the impact. So in terms of timeline, were you planning on waiting until you have that result before carrying on with the reports? Thank you.
Our agreed timetable within the Parliament is that the processes will run in parallel. So the report, our draft report, will be presented on the 22nd of June. After that, we'll start negotiations within the Parliament. And the impact assessment, we hope to receive it somewhere by October, but it will be just an additional information to the ongoing negotiations. Because although the Commission had the hopes, and we all had the hopes, most probably we will not be able to start a trialogue during the Irish presidency. Most probably it will be beginning of the next year, but we'll see. That's the present calendar that we are working according to.
Hey, thank you very much. I think then we have to close the panel. We could continue discussing this for quite a while, but there are more speakers waiting. So thank you, dear panelists, very much for this highly interesting insights and for you all for being our audience.
Very short. As we near the conclusion of tonight's debate, I'd now like to invite to the stage Thomas Petri, Bavarian Data Protection Commissioner, for his closing remarks. Thomas, please come. The floor is yours.
Thank you. Let's have a look at the start of today's event. Joachim Herrmann observed that the pressure to effect bold changes in the European data protection law and the digital rule book is now considerable. The Commission had taken a first step in this regard with the digital and the AI Omnibus packages, and in particular, Joachim Herrmann has also drawn our attention to the notion of the manufacturer liability for digital applications, which is now increasingly debated but not yet included in the Omnibus. The main question is, and this has also become evident today, what are the specific steps needed to achieve a future-proof data protection regime which reconciles clarity, consistency, simplification, and effective protection of human rights. In her keynote address, my colleague Talus reminded us of the key role that the EDPB is playing as the cooperation forum for European data protection authorities. She also underscored the various steps that the EDPB has already taken to facilitate compliance with data protection law and enable legal certainty. I share her conviction that the EDPB has regularly confirmed its willingness to engage in constructive cooperation with other stakeholders and ensure protection of human rights. In the panel discussion that followed this evening, we delved quite deeply into the details and progress of the two omnibus packages. In this regard, I would like to thank Marina Kaljurand for walking us through the recent developments. And I think the main topic was we have to want a common single market. That was the main message I received. We have to want it. This is more important than to rule and rule and rule and rule and rule. The same, of course, applies to her counterpart, Michael McNamara. Thank you for your giving us a look to the great deal of your successful work as the text of the AI Omnibus is about to be to a vote in the plenary. Speaking on behalf of the Commission, Renate Nicolai kindly provided us with some insights into the considerations and further proposals we might still expect from the Commission. Thank you for that. And I'm sorry, you have said so many things, but I remember, let's make the rules a little bit clearer. Yes, that's it. That's it. Thank you for that. And finally, Ms. Tsuku concluded his concise tour de force through the EU legislative process from the perspective of the Cypriot Council presidency and to try to find a good balance between simplification and effective protection of human rights. What does all that mean for companies, citizens, data protection authorities, and other stakeholders? What do we make of the amendments envisaged by the Omnibus? And thinking beyond the Omnibus, what can we expect in the medium terms for the future development of data protection law and the EU digital rulebook more generally? Ms. De Possen, outlined the challenges that companies are facing, not least in the digital sector. She certainly managed to make a forceful argument in favor for simplification, compliance, and reducing bureaucracy costs. Thank you for this implement. From the perspective of the data protection authorities, my two colleagues, Wojciech, your last name, it's a bit difficult, and Andreas Hartl, they shared some insights from their current practical experience. Andreas Hartl provided us from a national DPA perspective with a very concise overview of the most important pros and cons of the omnibus proposals. In addition, he quite rightly pointed out the areas where there is additional potential for a simpler, innovation-friendly data protection framework. For example, protection of children. Thank you for that. And he also remarks the increasing and improved cooperation with other stakeholders in the digital sector in the light of the Helsinki process. And of course, I am particularly grateful to Wojciech, I'm sorry about that, for warning against any disproportionate deregulatory zeal. I share his feeling that the omnibus certainly contains a number of potentially useful simplifications and clarifications, But nonetheless, the fundamental value of protecting the main principles of data protection, which is also enshrined in the Charter of the Fundamental Rights, is too important for us to restrict it without careful consideration. The discussion with you all brings two main clarifications for me. First, I've learned that German DPAs are usually unique in her positions, but they are not perfect. And second, even if we don't change the wordings of the legal definition of personal data, the SRB decision remains. So, personal, I am confident that innovation and data protection can indeed go hand in hand, ensuring that we maintain Europeans' high standards of data protection in the future without sacrificing our potential for digital innovation remains an ongoing challenge. In closing, I want to say thank you to our panel moderator, Johannes Baumann. Thank you very much for your skillfully guidance through the discussion. And a big thank you also goes to the team of the Bavarian representation in Brussels. And very vergelt's Gott to Armin Hartmut on this side. And I'm very thankful for your wonderful setting here in this area. I will now hand over to Leonardo Cervera Navas, Secretary-General of the EDPS, and wish you all a well-deserved dinner after these intense discussions. Thank you very much.
So, dear colleagues, I've been giving a very easy job for today, which is just to give thanks to the organizers, in particular the colleagues from the Bavarian representation to the EU, the EDPS colleagues, the panelists, and of course to the audience. So now that I have done my job, I can claim my salary as an Eurocrat. But as I have the floor, I would like to make a couple of remarks, if I may. The first remark is, I don't know if you heard recently, President Lula da Silva, the President of Brazil, said that the EU cannot afford to fail. The EU cannot afford to fail. And I think I cannot agree more with him. They say that there are three Europes: the Europe of the member states, the Europe of the citizens, and the Europe of the offices, the Europe of the Eurocrats, from Jean Monnet onwards. So I'm speaking today as representing the Europe of the offices, of data protection. And in this capacity, I would like to put you a question. At the end of the day, over all the noise, over all the threats, political discourse, what do you think our citizens, European citizens, expect from us? I think our European citizens expect from us that we uphold our values. And what does it mean to uphold our values? I think it means that we make sure that our societies, European societies, are structured and governed with a deep sense of morality. This is what makes us truly Europeans. And this starts with Article 1 of the Charter of Fundamental Rights of the European Union, which says human dignity shall be inviolable. cannot be more morality than this. So today, these days, I'm very proud as a Spaniard. We have the Pope visiting Spain. It was incredible. There were millions of people taking the streets to cheer the hope. And it's super interesting what he said, really, very interesting. He said that Europe should not respond to today's crisis with fear, exclusion, or polarization, but with human dignity, solidarity, peace, and hope rooted in moral responsibility. So, do you think that the GDPR is deeply rooted in moral responsibility? I think so. I think we all believe so. So probably that's the way to go, dear colleagues. Thank you so much for your attention and enjoy the drink out over there. Thank you very much.